Welcome. This meeting of the Planning and Zoning Commission of March 2024 will come to order. Pledge of allegiance, please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, please, Lori.
Chairman Richardson.
Here.
Vice Chairman Aton.
Here.
Secretary Grant. Member Childs.
Here.
Member Garrod.
Here.
Member Faison. Member Moscoso. Here. Alternate Member Findler.
Here.
Alternate Member Rogers. School Board Member Gilbert. Here.
Okay, we have a quorum. The next item is the minutes of March 6, 2024. You've been given a copy of the minutes. Any additions or changes you'd like to make them? Is there a motion to approve the minutes?
Move to approve as presented.
Member Moscoso seconds.
I'll second.
Okay. Any discussion? Roll call, please, Lori.
Member Childs.
Yes.
Member Findler.
Yes.
Member Moscoso.
Yes.
Vice Chairman Aton.
Yes.
Member Garrod.
Yes.
Chairman Richardson.
Yes. Chelsea, will you go over the quasi-judicial confirmation procedures?
The notice on the agenda states all persons who anticipate speaking on any public hearing item must fill out an oath card to be heard on that agenda item and sign the oath contained thereon. These cards are located on the table near the entrance to the council chamber or may be obtained from the recording secretary. This meeting will be conducted in accordance to the procedures adopted in Resolution Number 24-1997. Those speaking in favor of a request will be heard first, those opposed will be heard second, and those who wish to make a public comment on the item will speak third. The applicant may make a brief rebuttal if necessary. A representative from either side, for or against, may cross-examine a witness. Anyone who speaks is considered a witness. If you have photographs, sketches, or documents that you desire for the commission to consider, they must be submitted into evidence and will be retained by the city. Please submit such exhibits to the recording secretary.
Did you have that memorized?
I'm getting close to it.
Next item, there is no consent agenda. Maybe we should start adding some items onto that. First item under old business. Eddie?
Thank you, Chairman, and good evening, Commissioners. Item 8A, easement vacate application number 1, 2024, 300 Cheney, begins on page 9 of 39 of tonight's agenda packet. I'll read the first paragraph of the background on page 11. A petition has been received from Rodney Honeycutt, applicant, to vacate 0.15 acres of a 50-foot public utility and drainage easement located at the rear, the southeast corner, of the property at 300 Cheney Highway. The applicants are proposing to build a new 5,000 square foot office building with associated parking, stormwater, and landscaping. However, the proposed location of the stormwater pond conflicts with the existing easement. All required utility letters have been received, and there were no objections to the request to vacate the easement. And in conclusion, I'll read on page 12. Staff has no objection to the request to vacate the southeast portion of the 50-foot public utility and drainage easement within the rear yard. And again, none of the utility providers presented objections to the request. Thank you.
Does anybody have any questions of the staff? Okay, this time I'll open the public hearing. Do we have any cards?
Rodney Honeycutt.
Good evening, Chairman, board members. Rodney Honeycutt, 3700 South Washington Avenue. So my client is purchasing this for an office building. He's an ophthalmologist, and he wanted to actually own his own building instead of renting. And so he did a search and had a survey on the property. Everything looked good. We put together a pre-app plan, and when we met with the city, Public Works told us that when the right-of-way was vacated, there was an easement to be placed over the old right-of-way vacation area. And so they noted that they were only using the north portion of it, though, and that they would be willing to vacate the south portion if other utilities were. And so we made a submittal to vacate it. It's been kind of slow, a lot of staff changes. And then most recently, the reason it was tabled is we discovered why the client never knew about it, because the easement for the city was never recorded. So the owner had to record an easement so that we could vacate a portion of it. And so that's here tonight, requesting that we can vacate the southern portion that the city's not using, nor any of the other utility companies have any objections to it, as proofed in your package you have. And so I'm available for any questions or comments.
I have two questions for you. The first one, is it the entire, from the railroad track or the easement and the railroad track, west to Cape Run Road? Is that the piece of property? I
The
know.
piece, so Hibiscus Avenue was a 50-foot road right-of-way adjacent to the railroad track.
It was never,
And so
paved
there's
or
never been a road there. The city was using the northern part for, I think, some stormwater retention or a ditch. It actually discharges into the railroad right-of-way in the north part.
will it go all the way, it's the property we're talking about going all the way to Cape Run? Or does it end?
Yes, no, it goes all the way to Cape Run, yes.
Okay. My second observation, I passed by there today and I just happened to notice it, was there are 3 entrances on 50.
So we will not enter from 50, we'll enter from Cape Run.
Okay. I was real concerned about the first entrance being so close to the railroad track.
Yeah, that's not a good place to enter there, right?
Any other questions? Any other questions? Thank you.
Thank you.
Any other cards?
No more cards.
No cards. Okay, I'll come back to the commission. Do you have any questions or anyone care to make a motion? Mr. Member Garad.
Thank you, Chairman. I'd motion for approval of the easement vacation, item 8A, 1/2024.
Motion to recommend approval.
Yes.
Is there a second?
Second.
Okay. Any other discussion? Any other questions? Lori, would you call the roll, please?
Member Garad,
Yes.
Vice Chairman Aton,
Yes.
Member Findler,
Yes.
Member Childs,
Yes.
Member Moscoso,
Yes.
Chairman Richardson.
Yes. And this will be heard at council's meeting next week, right?
Correct, March
Okay.
26th.
See how simple that was? Next item is 9A.
Yes, sir. Item 9A is conditional use permit number 1, 2024, TRG Self-Storage. The applicant has requested this item to be tabled to the April 3rd P and Z Commission meeting and the April 9th City Council meeting. Their concept plan is still being worked on.
I have one question. Where is that warehousing complex?
The property was recently annexed into the city. It's off of South Street, north of Highway 50,
Oh,
south
yeah.
of Fox Lake Road.
Oh, yeah. Any questions?
Yeah, I would just say I appreciate you putting in the response from the applicant in our packet.
Any other questions? Is there a motion to table?
Move to table as requested by the applicant.
Member Findler,
Seconded.
any discussion? Well, it can't be discussed. It's a motion to table anyway. Roll call, please, Lori.
Member Childs,
Yes.
Vice Chairman Aton,
Yes.
Member Garad,
Yes.
Member Findler,
Yes.
Member Moscoso,
Yes.
Chairman Richardson.
Yes. Okay. That was a real short business, 10 minutes, 11 minutes technically. And the next item is you, Chelsea. Let's see.
Do you want to do me or petitions and requests?
Yeah, petitions or requests. Any petitions and requests from the public? Oh.
Hi, my name is James Troutman. Address is 1705 Barnum Avenue. Good evening, Chairman and members. We received a letter in the mail about a property next to our property being rezoned possibly for a community that they want to propose to build there. So I'm not really sure what my rights or anything are. So I'm coming to these meetings to figure out what that is. Because tomorrow we have a meeting, I guess, for the
Is that a community meeting?
I believe it is. We have an address to go to tomorrow. I don't know where that.
Sir, was that notice sent by the city or from the applicant? Do you know? Okay.
Yeah, I'm not sure.
The reason I ask
It might
is-
be from the applicant, from the developer.
Okay. The reason I ask is because one of the city's requirements is that if an applicant is requesting a rezoning, outside of the city's process, the applicant is responsible for hosting a community engagement meeting to inform the neighbors. So that could be what you're speaking about, and we wouldn't have more information about the specifics about what's being presented at that meeting.
Sure. No, that's fine. We wanted to come here and see what that was about first and then go there and work the process, I guess.
You know you're live on YouTube. You're a YouTube star tonight.
Yay. So,
Thank you.
but no, I'm concerned for the community and of course for our property as well, because we're getting a lot of traffic and everything. So that's going to be taxing on our community as far as police, fire, everything. So that's part of the reason why we're here too. So.
I would assume it'll come before us whenever it's ready, and we don't have the slightest idea when that'll be, right?
Okay. Sure.
And then we hear it and make a recommendation, and it ends up at city council.
Sounds good. Thank you. for
Thank
that
you.
Information. Thanks.
Any other citizens want to be heard? Okay. Item 11A, Sunshine Refresher. Have you got that memorized too?
Good evening, commission members. How's everyone doing tonight? Did everyone receive the email that I sent you on Friday? Who didn't get it? Megan didn't. Okay, well, I'll make sure that you receive what I've sent. I'm going to go over what I've sent. It was some materials that I would hope you would save and store and not include in an agenda packet so that it wouldn't get lost in the future, because those types of materials. And so I'll send it to you right now, actually, and if you want to just confirm that you received it when you can, when you get a chance, no rush. Everyone else got it? Okay, so the contents of the email were just two attachments and the summaries of what was attached. The first was an ordinance, 23-15, that recites the rules of city council, and I provided that to you so you know what those rules are, most specifically because I know that the Rule 13 is referenced as a tool that you can use if you want to revisit a subject matter. It's not necessarily called Rule 13, except for that that's the number of the rule that it is. It doesn't exist as Rule 13 outside of Titusville as part of my message to you. So if you were to say it outside of Titusville, somebody might not understand what you're talking about. It's specific to the rules of city council, and it says that, pull it up and I'll read it to you. It was slightly amended about speaking times at a prior city council meeting, so I sent you the most recent version of it so you could see that as well. Rule 13 says, a motion to reconsider any of the proceedings of the council will not be entertained unless it is made by a member who previously voted in the majority, nor shall it be entertained at any other meeting than the one at which the proceedings were had or the meeting immediately following. So that's the rule. City council has that rule, and other boards and commissions have adopted it as their own also. And if you need to revisit a item that was voted upon at your last meeting, that would be one of your methods for doing so. That was just a really small little anecdotal thing I wanted to mention. The larger portion of my email was a case that I provided. And I have a portion of the case on your desk, but Megan, since you didn't get it, I actually have an extra hard copy I can give you. So this case resulted after 3 city council members from the city of Sebastian, which is just south of us, went forward with a meeting that the city manager had canceled during COVID. It was in 2020, and the meeting was canceled due to whatever the reason was. But these 3 council members decided to go into the council chambers and conduct a meeting where nobody else was invited. They had their government-issued pass keys to the building, like you all may or may not have. If you don't, but the city council members here have these cards where they can gain access to the building. So that's what they did. They came into the building. There was no public present. There may or may not have been some meeting minutes kept by the individuals, but there was also no notice. So they failed to comply with the Sunshine Law. And I thought this case was really illustrative of what could potentially happen in the event of sunshine violations. So I wanted to give you this real story and this recent history. I'll back up and let you know that the Sunshine Law is founded in the Florida Constitution. Article 1, Section 24B of the Florida Constitution says, all meetings of any collegial body of the executive branch of the state government or of any collegial public body of a county, municipality, school district, or special district at which official acts are to be taken or at which public business of such body is to be transacted or discussed, shall be open and noticed to the public, and meetings of the legislature shall be open and noticed as provided in Article 3, Section 4E, except with respect to meetings exempted pursuant to this section or specifically closed by this Constitution. So this section provides that there can be exceptions. The legislature has interpreted the Constitution to then provide the public meeting law in Chapter 286 of Florida statutes. So that's the background. In Sebastian, I told you what happened there, but then there was this whole case because there was a couple of other layers about perjury and other things that needed to be decided. But I think that we all benefit from the opinion that was written because we can use these takeaways. I suggested in my email that you all go to page 8 of the opinion, where the concurring opinion went through 7 key takeaways. I then copied the language from the case law and printed out a sheet for each of you to take home so you could keep it. I have explained now the background of where this came from, and I find these 7 key takeaways to be super helpful. They're also in a judge's own words, so that's the source of them, and they're a little bit more brief than the law actually provides. For example, it says, there's rarely any purpose for a private meeting or communication between 2 or more government officials who are both subject to the Sunshine Law. It doesn't really get into the nuance here that you can talk to city council members and that the Sunshine Law is specific to your body. And so that's a point that I wanted to bring out, that the Sunshine Law is specific to you as a board member of the Planning and Zoning Commission, and it prevents you from talking to the other board members of the Planning and Zoning Commission about any item that may foreseeably come up before you for a vote. So that is the background of the Sunshine Law and a case example of what has happened. I was hoping that maybe some of you might have some questions or nuances that you might want me to get into. I know you all have been initially briefed on what the Sunshine Law is and public records law, so I didn't want to repeat anything that you already understand pretty well. But if there's something that you don't understand, please raise that question.
I have one concern. If an item has already been before P&Z and it doesn't look like it'll ever come up again, can we informally talk about it?
I would definitely say no, that's not recommended because every ordinance is subject to revision. And there's always the possibility that one of those subjects could be brought up again in the near future or in the distant future. So just because an issue has been decided, I would say that that falls into the category of something that's foreseeable to come back before you.
Member Charles.
So like, this happens frequently where multiple of us come to a city council meeting, so it's not our board meeting. But there's no requirement to because we don't come to the city council meeting to talk to each other. It happens incidentally, and it's not usually about, it's never about anything about the board. But is there any requirement to tell the public that board members will be at a city council meeting?
So sometimes the city does post if there's an event or certain things that 2 or more council members or board members may be present. Yes, we'll do that as an abundance of caution. But that doesn't stop the conversations that we can't control.
Right,
And
yeah.
so there is concern of public officials attending another meeting where 2 or more officials are in the audience. And if you are weighing in on something and then the other board member is hearing what you're saying about something that, yes, that could be construed as a sunshine violation.
Right, yeah, okay.
Member Moscoso.
Yeah, I get what you're saying, because, I mean, typically it comes to us first and then first reading, and then the hearing. And a lot of times recently that has been swapped. And so I think it makes it a bit difficult. So I think that was a good question to ask.
I can give you an example about how that has played out in the past here at City Hall. We had issues, when I first got here about 10 years ago, there was a lot of issues going on at the county. The Brevard County Commissioners were talking about things that impacted Titusville. And the mayor was very interested in chiming in on how he believed that would impact the city of Titusville. Other city council members also wanted to do so. Our advice to them was not to have 2 council members in the same room at the same time talking about the same subject matter that could come back before them, per the Sunshine Law. Because if you're in the same room listening to what one of your council members on your body is talking about, that's going to come back before you, just like it says here on this sheet, there's a recommendation from the judge for that exact type of situation. What does he say to do? Leave. Right. Leave. Number 6, when in doubt as to whether a meeting or communication, either directly or indirectly, between 2 or more government officials may be illegal under the Sunshine Law, the easy answer is leave.
But the exception being that only if it was posted.
With minutes. He's going to keep the minutes between the P and Z members.
Posted minutes for the P and Z, not because it's minutes of the city council.
Right.
Okay.
So you're all able to go and attend the city council meetings and sit and listen. But when one of you starts opening your mouth and the others are chiming in and going back and forth, then you're having a conversation about something that may come before you. And that is against the law.
For instance, though, we could all watch that person say it on a YouTube video after it's been broadcast, though. So I don't see.
But are you sitting and listening and commenting after she talks about it in the same audience?
I guess it depends on like if you're commenting. I mean, how you determine that you're commenting on what they just said. Like, you know, like how you determine that you're commenting on what they just said.
The black letter advice would be that the first person who comes and speaks would have taken the floor. And then the next person, how do you know that the next person isn't commenting on what they heard you say?
Yeah.
It would be impossible to determine. But the cleaner way would be to not continue that conversation or conversation environment, the communication environment that's going on.
I see. All right.
Member Moscoso.
Yeah. So yeah, an example of that would be when the Live Local ordinance came up. A few members did get up and speak. Would that be considered a violation of the Sunshine Law?
I think it could be.
Okay. So
I think it's, a good question for the Attorney General, but there's no reason, you are a citizen, but you're also a board member, and you have duties as a board member that you need to abide by, and so you need to consider that before you get up and speak when you know other board members are in the same room.
So in that case, a best practice would be to send an email
To the council.
to the council.
Yeah.
They don't read them.
Thank you.
There's been several cases that 3 or 4 of us are at the council meeting, and we choose to get up and speak. Are you saying that when one member speaks, the other 3 should leave the room?
I didn't say you have to leave the room. I said that they should not necessarily speak on the same topic as the first person has already spoken on, to avoid the appearance that you're commenting and having a communication back and forth on the same subject matter that may come before you.
We've often are at council meetings and disagreed.
I didn't write the law, but I'm obligated to tell you how it has been and could be interpreted.
Vice Chairman Aton.
So I just want to clarify one thing, because the way this opinion's written, and you kind of addressed it, but I'm not sure I understood it, is so under the part about number 2, where there's rarely any communication where between 2 or more government officials or both subject to sunshine law would read that we're subject to sunshine law and a council member is subject to sunshine law. But then I've also understood, and I think you maybe just said it, that we can have a conversation with a council member.
The
and
sunshine
not
law
be
doesn't govern your conversations between you and the member of another collegial body
Okay.
as
but-
council.
Yeah.
It governs your
That's why I
private.
wanted to clarify, because this is kind of unclear, because we are both subject to the sunshine law,
Mm-hmm.
but not the same conversation. And I just want to clarify that out of an abundance of caution.
Yeah, I think in some ways the sunshine law is handcuffing. Not necessarily that we'd violate it intentionally, but if members go to city council to speak their own opinion on the same subject, I think that's a fine line, that it may not be a violation of sunshine law, but I'm not going to ask you to ask the
I wouldn't
Attorney
want you
General.
guys to be the test case on that.
Any other questions? Member Garrett,
I just wanted to add a little bit of information. I'm sure Chelsea's
you
familiar with
need to
it.
pull the mic down.
I'm sorry. In the same vein as pretty lack of smartness on behalf of those folks in Sebastian Inlet. Reading the whole thing was incredibly daft, but that's just those 3 people. On another one of those events was the Hillsborough County Commission, when the commission was seated and then people with the handcuffs came in and took the county commission away with them for violation of sunshine. They were working between the planning commission and the county commission in an event that unfolded before everybody's eyes. But the story about the being arrested off the dais was kind of shocking. That was just one of those things that happened. I worked for a person who was one of the county administrators when it happened, and it shocked everybody that it'd be like Eddie sitting there looking at us, and all of a sudden the 2 gentlemen with badges come up here and take a group of us away. Just
Well, he might like that.
yeah, these things do happen. These things do
I'm
happen.
kidding. Any other questions? Any other comments? Chelsea, do you have anything else to add?
I really thought this case was eye-opening, and I hope you did too. And I hope that if you have any questions about anything in the future, about anything sunshine, public records law, agenda items, that you feel comfortable coming to us to, discuss and talk through whatever the concern may be, because that's what we're here for. We're here to keep you out of trouble. And these resources are available. There's more resources available if you need them. There's webinars, there's training links. I can provide those types of things if you need them. But my office is always going to give the most conservative advice. And,
Yes,
and that is to
definitely.
protect you.
Is there anything regarding the staff and are subject to the sunshine law or something similar?
They can't be conduits. We can't be
Yeah, that's
used
the important
as a
thing.
tool. Nobody can.
That is important.
Nobody can be a conduit. Nobody is allowed to be a go-between for any of you all to express your opinion. And you can't be conduits for other members' opinions. You can't be talking, the same concept with number 6 applies in many unexpected conduit situations. If somebody comes up to you in the bakery or Publix and starts talking about something and then mentions one of the other board members' names, then that's your key that they're working as a conduit inadvertently. They don't know what they're doing. But if they tell you, oh, Joe Richardson just said blah, 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 he's gonna da, 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 you have to walk away. You have to stop the conversation. You have to say, please don't tell me any more of that. Or, whatever you think is best for the scenario. But you don't know when those types of scenarios may come up because you don't plan on them and the other people aren't planning on them, but you need to avoid them at all costs.
The point I tried to make in the last meeting is if we have these calls from the staff, which I think are working well, I don't criticize them at all. We've got to be careful as members to not let the staff know our intention to vote no, our intention to vote yes, because we're making them conduits. We're making them conduits. Member Moscoso.
Yeah, on that thread, I think you mentioned last time that if we even drive by a property and question that we need to disclose that. Is that correct?
If you're making a regular visit or a regular driving around town, for quasi judicial, the best advice that we have is to disclose if you've gained any information that has changed your opinion on a particular project. If there is a question, have you visited the site? And if you went out of your way to visit a site, then that should be stated. I think if you're just driving by, I don't believe that's necessary. Like if you're not going out of your way to drive by something, then that's just living in Titusville.
Yeah, like when I told the applicant earlier, Honeycutt, that I passed by I was driving down Highway 50 and I noticed it has 3 curb cuts. I don't think there's anything wrong with that.
No, I think it's better to announce things you may have noticed than to know something and then keep it to yourself. I think that is the act of curing any defect in a decision by first telling the applicant what you know or don't know about the property based on your perceptions of what you've seen. I think that should come out so that they know what to address in their response to you.
My next question would be, have we ever considered doing site visits as a board? Because a lot of times we get our packets and to be there visually and see the environment would be very helpful. And I know you've got to be really careful, but I know that a lot of other cities do it. I've got 2 examples of cities and how they do it, how they announce it, that it's considered public, so the public can come. Obviously, you have to have the developers or the property owners' permission to do it. And then when you're on site, you can only ask basic questions to the owner of where is this going to be, where is this going to be. There are minutes taken, but I've seen some cities do it, and it looks like it's been pretty effective. It's these quick 15-minute visits, and it's just so that the board has a chance to go together if they're willing and able to, and any members of the public to go and actually see a visual of the property, take that in, and then come back for the public hearing where those questions would be asked. So it's not a chance for the public to go in and go after the developer or for the board members. It really is kind of like a mini field trip just to take in the environment. So has Titusville ever done anything, or would that be something we could consider doing? Because I know it wouldn't be something we would do for every piece of property, but for me, I would love to do something like that, to go out and on case by case, if a commissioner said, I would really like to go out and see this piece of property, can we make it open to the public, a 15-minute visit, if we get the permission of the owner?
To my knowledge, there's no process that has been established for that type of activity.
I'm gonna, if it's okay, I've got some papers I want to pass out to the commission. I just want you guys to see how it's done and how it's advertised, if this is something we might consider in the future.
We have done that before. It was about 30 years ago, when we're talking about, well, like, for example, the comp plan involved in downtown. It was advertised, so everybody would know about it. And we did walk the downtown area with the planner, explaining what was in the comp plan as far as the buildings and everything, and some of the public went with us. And there was somebody not recording it, but at least made notes. And that was advertised and that was legal. And it really made a difference. And I'd say too, it would be nice if we had a chance to do that before we finally submitted the comp plan. Give me some more. Finally submitted the comp plan for approval to walk in the downtown area. We did that in the past with an attorney I thought was conservative. Probably not as much as you are, but Dwight Severs went with us.
What year was that?
It was sometime in the late 80s. We did take
I'm just not knowledgeable about that.
Well, some of the staff wasn't even born in the late 80s. Vice Chairman Aton.
Now I'm trying to remember what my question was. I'll think of it.
Any other questions? Okay, any other questions? Anything anybody else wants to add? Okay. Staff report.
Yes, sir. Thank you. I have an update for you on application SSA number 2, 2023, the registry at Sandpoint. If you remember, P&Z tabled that item to the April 17th meeting at the request of the applicant. Since then, the applicant has requested that the item be tabled indefinitely. And so just giving you a heads up that this item will appear on your April 17th agenda, and their request is to table it indefinitely at that point.
Okay. Member Garrard.
Eddie, I have a question. I brought this up to the applicant point blank about. Move forward. I'm sorry. Pardon me. During the meeting, I brought that up point blank with the applicant about why not withdraw the application, start anew. Being familiar with continuance to specific dates not requiring advertisement because you've specified that date where the meeting will occur, as opposed to tabling indefinitely, seems to me that what would be prudent is the applicant withdraw his application and make a new application, which also covers the cost staff has to go through, the county, the city's staff in general, not just the Planning and Zoning Commission, of course, ourselves, for a meeting that is on the first dime they paid, and this runs on. And I myself, I oppose that. I think if they want an indefinite continuance, they need to withdraw their application. That's my opinion. But during their discussion, I'll bring that opinion up for discussion.
Just for the commission's awareness, the benefit to tabling to date certain is that the applicant doesn't need to pay a re-advertising fee every time an application, we have to advertise it in the local newspaper. So that saves them a couple $100s from having to re-advertise the application. By tabling indefinitely, the application is still active. So if in the future, the applicant wants to pay the advertising fee to get it heard at a future meeting date, they could, which is different from withdrawing the application entirely, which is they would have to resubmit the entire application and pay the advertising fee.
Any other questions?
Just a follow-up, I understand that, but just speaking from a civil servant standpoint, the fact that there's an establishment where you have a fee you pay for your application's review and processing, and on the other hand, tabling indefinitely because it saves a developer a couple $100s, it expedites the aspect of its review because you're only going to advertise, you're not going to go through the litany of review that staff should do. And my concern for staff is that the applicant comes in and revises the plan enormously.
In that case, if the application is changed, then they would have to pay the application fee again.
All the above is true. I again express my opinion is, given an indefinite postponement, the applicant should take the high road. He should withdraw the application, start new when he's prepared to discuss the matter. And I'll discuss that at the meeting when they ask for the indefinite continuance. Thank you.
Anything else?
No, sir, thank you.
Chair, City Attorney, do you have any other report?
Nothing additional.
Okay. It's my report time, so did any of you see what appeared on Fox 35 about Brevard County running out of water? You should see that or read it. It was also posted as a news story. And that really concerns me, thinking about all the annexations. Why we've seen so many annexations in Brevard County is running out of water. It gave some figures, and I don't know how accurate they are, about Brevard County growing 24%. And at this point, I wonder if we should follow the mayor of Sanford's and ask to pause, because we keep getting numbers of customers we're serving on the water. They range from like 50,000 people, family, including families, that we are serving water to. And there was something, we got a water report that said we anticipate serving this many customers through 2035 or whatever it was. Y'all, 2028, yeah. And then later, a couple of months later, it stated before City Council that we're currently serving 60,000. And, you know, I just want you to consider pausing for a while, maybe a month, maybe 2 months, because, you know, it's as simple as, has anybody experienced a decrease in water pressure? Your water lines can only serve so many people. And at certain times of the day, you have difficulty, I have, in filling up the washing machine or taking a shower. It can only serve so many people, and you keep adding people, apartments and new developments. I'm really concerned about it. That's something maybe we'll talk about at the next meeting, or I want you to give us some thought. And I don't know if we can share anything because it'll be a violation of sunshine law. Just look at Fox 35, Brevard County water supply. Now, I'm not saying that is a fact, but you should take a look at it, how concerned this county is, and people that live in this county are of the water supply. And
Just to clarify, this meeting is an opportunity for you all to talk to each other about things that may foreseeably come up at this meeting. Only at this meeting, when the meeting's on, is when you all may talk to each other about things that may come up before you. You can talk to each other when you're here. The window of opportunity to discuss things, like you've just suggested, is from when the meeting is called to order until it is adjourned. When the meeting is adjourned, that opportunity ends. Before the meeting starts, the opportunity hasn't begun yet. But to provide other members with your opinion on something like water supply is perfectly acceptable during meeting hours.
yeah, but I think they should see it and read it on their own. I'm just saying, take a look at Fox 35's report on the water supply in Brevard County. I'm very concerned about that. You know, I think we've, like I said, got to pause development for a while Sanford has done the same thing. Member Finlander.
I was just only going to ask, for the Sunshine Law, we're allowed to share articles and links with each other as long as we're not giving our opinion or anything like that, right?
That's a fine line. I'd recommend against it.
Okay.
Because if you're going to share resources, then the best way to do that is through staff or at a meeting.
Okay.
Yeah.
That You're just gonna, we don't want to set you up for failure by saying, yes, that's an okay practice, and then you one day write a commentary, one sentence in it to another board member. That would be prohibited, but
Sure.
you can't
Was
do
it-
that. So we would recommend against it.
Was it Eddie or Brad that sent out something about trees? An article about what they're doing in Canada. And it says that was provided by a member, but didn't name who it was. That you can place a value on the trees. That was an interesting article. And I guess that's the way to share it. It's just forward that to the staff and ask the staff to share it with the members of PNC. That's my report. Any member have a report?
I do.
Okay, yes.
I just wanted to let everybody know that the School Board of Brevard County has approved the 2024-2025 Student Accommodation Plan. And am I permitted to share that with the members through SharePoint or, and I'll do that if you're all interested. Yeah,
Yeah, send it to staff and they'll send it to us.
staff is you and Eddie.
Yeah, and then if you want us to talk about it at the next meeting or a meeting in the future, just state that this is an item that you'd like to discuss. And in regard to that article or broadcast on Fox 35 about the state of water, I'd like to put it on somewhere in the next 3 meetings where there's a lack of really a bunch of items on the agenda to talk about it.
Can I get a consensus from the board members that you'd like to have that on one of the future agendas?
Is there a consensus?
Yes, there's consensus.
Thank you.
Just, would it be possible to get somebody from the water department to educate us on capacity and maybe even ask them to watch this since we're all gonna watch it? And, you know, it's off the internet now, although it's broadcast news, but it's the old, you can't believe everything. But they should have an opportunity to kind of defend themselves, for lack of a better term, or educate us.
You
So-
can't believe everything you see on TV?
Yes, and I do want to make the distinction that Brevard County is a different utility provider than the city of Titusville. The city of Titusville has to prepare its own water supply plan, and so we can provide that and go into the details.
But we have seen a bunch of annexations and I wondered why. Okay.
Yeah, and it wouldn't be bad to address sewage as capacity as well, because I'm on a different board and there's a lot of discussion about, especially on the south end of town, about sewage capacity as well.
DEC, yeah. Member Gilbert, have you?
I just wanted to explain, in case there are people that really don't know what it is it's a document that talks about the school capacity, actual enrollment, projected enrollment for a 5-year period, and that's how they do their planning. So I just think it would be helpful. It's helpful for me when I hear about new developments coming through, and helps with recommendations as well.
Point well taken. Member Garad.
If while you're researching in preparation for a future discussion on what was called the water wars, circa 1990s, Brevard County was running out of water in Lake Washington and sought to establish deep wells in Osceola County, which ensued an interesting feature of comprehensive planning in which they turned consumptive use permits into a comprehensive plan amendment, and that allowed the county to make decisions based on a legislative format. So if you didn't want Brevard County to take water, just decided they couldn't take water. Osceola County prevailed in that situation. Brevard County's water, they had a name for it. It disbanded after the unsuccessful attempt. So 30 years ago, the same problem was in existence because the water consumption is one thing, it's the provision for fresh water out of Lake Washington that's the other problem. And the other footnote is if you have an opportunity to visit Martin County, ask for a glass of water because it's always going to be desalinized water. They ran out of water a long time ago. So that was their solution. However, their water rates reflect what happens when you're having to use desalinization as a potable water method.
And I assume you know that since you were assistant county manager?
Something, yes. And if you just Google Osceola County, Brevard County, and water wars, you'll hit on the Sentinel articles. I just double checked it. I thought it was in the 80s, but it was in the 90s.
Member Childs?
About schools, last year Governor DeSantis signed the bill to expand the Step Up Scholarship to no income cap for applying for that. And I was wondering, has that affected the public schools in any way? And because I think we kind of saw it last year with Lake Fern Montessori School expanding their operations, and we might have more developments for private schools that happen because of this. I think every year they're appropriating more money for it, and I think they're kind of going in that direction of trying to fund more of a voucher system. And is there any indication with the numbers that they've put out of that it is heading in that direction? Probably not like a decrease, but not as high of an increase every year, or do you know if they've seen anything like that?
Are you referring to enrollment in the public
Yeah.
schools versus private schools?
Well, yeah, more so probably every year you have more and more people, more kids are, population's growing. But if it's been growing at a 5% rate every year, but now that scholarship and is throwing more money at it, is that going up 4%, 3%? Is it affected, you think, or?
I think it is affecting it.
Yeah, you just don't kind of
But
see it yet.
I
quite yet.
don't have numbers for you, but I think it definitely is.
Yeah, and I think we'll see more of that in front of us too, if they're wanting to build more schools in a certain place that maybe they can't, because I think private schools are going to start showing up more, and some of them that are already in existence are expanding. I have a 5-year-old now. I have 3 adult children, but I have a 5-year-old, and I'm looking at schools, and I'm thinking about this too, and I'm thinking there's a lot of people when you're going to a school, they're saying we're expanding, and it's a private school, and I'm thinking it's because we're giving more money to it as a state, and so I think we're going to see, and I think we need to keep that in mind too. We're going to see maybe more schools trying to be developed new or expanding. So, good or bad, I think we need to keep it in mind of what that looks like and what we want it to look like, because I think we're going to be hit with it regardless in the future. So we probably need to start thinking about what we want, what's good for our city in those regards. So, thanks.
Any other items that any member has? We tried to go to your bachelor party, and Eddie was driving the bus, and it broke down halfway to Nashville.
I can report Nashville was fun. Yeah.
So if we all went, we'd have to have meeting minutes for it, right?
No, we didn't go.
And Brian, and everyone
we
would have to
we
be
wouldn't
invited.
talk. Of course, we'd never do anything like that. We wouldn't talk anything from here.
Any other items from the staff or from the attorney or any of you? This meeting is adjourned.